Hello, Toolboxers, and welcome to episode 286 of the Immigration Lawyers Toolbox. Really happy to have you in again because we have one of our favorite episodes, which is an interview about federal litigation with Kevin Gregg of the Curtisman Law Firm. This is always a real popular episode type, so I'm glad we got another monthly one in, and Kevin is doing great. You can catch his podcast, Immigration Review Podcast, wherever podcasts could be found. And so the goal we have here is improving your practice and your life as an immigration attorney. We're doing everything we can to get you there, even having competitors on our show to say, hey, go listen to their podcast, because that's the weird nature of immigration practice, where fully supporting each other helps everybody out. So that's what we're here to do. And along that line, we also do other things like have a magazine where we share a lot of information, which a new issue was published, issue number 7. I have an article in there talking about the lawful presence and 3 or 10-year bar, how do you accumulate the days, all that kind of stuff, which I found practitioners have a difficult time grasping. Always seeing stuff in the Facebook groups where people are making mistakes on it. So I thought I'd throw my 2 cents out there and explain some of that for newer practitioners and for existing ones. Plus, we have other stuff. I learned so much from this one myself. For example, one about, what the H-2B visa is and how that process is, something I've never done before. It was very enlightening, a lot more. So definitely catch it. Just go to ILT.com and, check the magazine section of it, and you're going to enjoy it. And so we do other things too. We have the second session of our monthly mentoring session for solo and small firms who are growing, where we share our thoughts, our successes, failures, growth plans, strategies in a real open session. I'm really enjoying it. I'm getting a lot of it myself, even though the team lead on it, the group leader on it. It's just exciting. When I have members, I'm going to ask them to leave reviews too, so you can see it. I definitely recommend doing it. There's a fee for it, but email me and I'll break it down for you. info@immigrationlawyerstoolbox.com. I also want to thank the sponsors of the magazine, of the podcast, in particular DocWise, who's always been a long-time sponsor, DocWise.com, all-in-one form system, which many of you already use, but I want you to know, you get extra discounts if you get their annual plan. They got so many new things that come up when we do a regular quarterly session with the co-founder of the firm, of the company, and about what new products are coming out. And there's always, cutting-edge products coming out from DocWise.com. Definitely should reach out to them, talk with them, the salesperson there, do a demo, and see how it works and help your law firm become a greater law firm. Having said all that, if you like to support the podcast, what I would really appreciate is if you tell friends and colleagues about the podcast so they can listen to it too. Send them a copy of the magazine, share a copy of it using the link. Just let the word out so people know about the Immigration Lawyers Toolbox, because the more success we have here, the more product and sense of more educational content we could produce, and get more people involved and have better guests. If we're more famous, higher guests will come to share more information. So the more you support the podcast, the more you're supporting yourself and your practice. Now, everything we're going to talk about here is not intended for individual legal guidance. It's general education only. Legal stuff changes a lot, and your case may be different. So talk with an attorney. If you're not an attorney, listen to this. Having said all that, let's get the show started. So Kevin, thanks for coming on the show again. I appreciate a regular session. How's everything going with you? Any plans coming up for the next 30 days?
Hey, John, good to see you again. Yeah, I'm glad we can do this now. In 2 days, I head from San Diego to Arlington, Virginia for the Federal Bar Association Immigration Section Conference. Going to talk about waivers. It's an awesome conference. Big fan. And it's not just because they pay me to say that, because they actually don't pay me at all.
I was going to say, you get paid nice. Are you keeping track of all these miles? Do you use the same airline, or just to keep the mile system together, or?
Well, I definitely, I definitely use my flight number, with American and all the things like that. So yeah, the way I work, I don't know how you do it. I wish that there was more teaching lawyers how to be organized. I try to be organized, but I could definitely do it better. But for me, I've got a lot of things, but I also have an Excel spreadsheet where like every day it's descending in date order, and that has things I need to do, deadlines, all of that stuff. And some of those are literally like Delta miles going to expire, like July 1st, 2024. Like that's on the list. Hilton points going to expire. So those things.
I don't do as much travel here as you do, but I'm like, hey, you're always on a plane. Do these miles go anywhere? Because I hear people have tons of miles and they get first class and that. I'm like, how much do you have to travel to be able to pull off first class trips and stuff?
That's never happened to me. It's never happened to me, but I'm looking forward to it one day happening where I get to be first class because of miles. But no, that I mean the FBA conference is great. I mean, AILA National too. I'll be there in June. Hope to see you there
Mhm.
too, all the
Yeah,
way
for
in
sure.
Orlando. Although Orlando in June is just the worst time to be in Orlando, but it's still Orlando. But the FBA conference is great because like they send out the list. It's like probably a dozen judges and at least one BIA member, BIA staff attorneys, federal judges, ICE attorneys, oil attorneys, especially this year because it's in the DC area. It's a great conference. There aren't really any other conferences where all those government attorneys show up. And as I understand it, and the judges, as I understand it, at least with the government attorneys, they don't get to use their annual leave to do it. Um, so really they're just using, I mean, no, they get to use their leave. They don't get like special leave to go to a conference. So they're literally using their vacation days to go to
Wow.
this conference. So like they want to be there, you know?
That's dedication. It's good to show on their end too. They're into, expanding the knowledge base and helps make things smoother the more they share this kind of knowledge. So good stuff. Kia brings back some good reporting. I'm sure you're going to talk about on your podcast, the Immigration Review podcast. But share some of the tidbits of knowledge you have here as well when you get back.
I'll try. I know for a fact that Judge Gelpi on the First Circuit and the newest member of the BIA will both be there, and they've both issued decisions recently that I've got a gripe with. So I look forward to telling them what I think about it. I'm just kidding.
I wonder if they're going to be like celebrity shocked when they see you. They're like, "Oh, we listen to your podcast, the judges."
That is ridiculous. I mean, that is an honor to say. I find that impossible to believe, but that there was I spoke with a temporary BIA member last year who did come up to me and said that she listened to my podcast, as did a lot of staff attorneys at the BIA, and I couldn't believe it. Like I could not. She wasn't like celebrity shocked, like you said, but
Yeah.
I like she was like having this conversation with me, and I'm like, oh my God, I can't believe this. This is ridiculous. But
Did that cause you to censor yourself a little bit?
I
Are you
already it's
cautious?
hey, never a bad thing to think in
Yeah.
the back of your mind the judges are listening. There were some that actually happened early. It all comes back. I actually early on in the podcast, I talked about a Second Circuit decision in which a district court judge was sitting by designation, and I kind of made like a comment. It wasn't disrespectful, but it was, if I recall, the judge, I won't name him, like dissented and would have completely blown up Second Circuit precedent doing it. And I said something along the lines of like, oh, really using your opportunity to say what you want, like district court judge saying, I want to blow up all the Second Circuit precedent if I could. And an attorney reached out to me, actually. This was one of the early episodes, like, Evan, that might have been a bit too much. And I took that to heart. And I haven't done anything like that since. Fast forward to last month, I did oral argument at the Ninth Circuit, and that judge was one of the judges on the panel. And now that judge, there's no way that judge knew who I was, listened to the podcast. But if he had, he would have
Yeah.
known that at one point I had actually named him by name. That wouldn't have been a great situation to be in. So I haven't done that again. Period on that story. We won that petition for review today.
Nice.
Today,
Wow.
the case is getting remanded back for a improper nexus finding and asylum, unpublished. So I don't
Yeah.
get to do it on my podcast, although I'll definitely mention it. But so yes, I don't. I really try and limit what I say about the judges on the
It might as well.
podcast.
I mean, there's more harm than any good that come out of calling out a single person on this kind of stuff. So
Yeah.
just always try to talk. I get carried away sometimes, get emotional with all the stuff that's going on, especially in Trump's administration,
Yeah.
where you just want to like yell and curse. But it's always better to just keep it on the facts and the fact patterns, and I get into that.
I agree. My only difference, though, is I try to discuss patterns in how
Yeah,
judges are behaving. I mean, there was no that's facts. What the BIA was doing during the last
yeah,
administration, the fact that the Trump administration forced out certain BIA members and then expanded the BIA and
yeah,
then packed the BIA. That's just facts. But
yeah,
judges with a certain judicial philosophy or the type of language being used by some of by some of Trump's circuit judges. that I name names when they do it on the podcast that are just,
Yeah.
they use a certain language that they're being intentional about to be combative. And if they are doing that, I don't think there's anything improper to acknowledge
And what kind of
that's what
language
they're
do they use that's
doing.
different? Using the term alien kind of thing or something else?
No, not even like that. There are certain judges who are just at war. They're at war with their fellow judges and are using just their writing style is just kind of disrespectful
Oh, I
to
know
and
Chevron
to
does dissents like
immigration,
that.
just disrespectful to the parties and to the court's prior immigration precedent and to the arguments, and very dismissive. I think that maybe there's a desire to be more accessible in their writing, but to me, it just kind of comes across as mean. And
Yeah.
I think that's the case with other judges on the bench as well in their courts. And so when that happens, they're clearly being intentional. So I
Yeah.
don't think there's anything wrong with recognizing that, but I try to even avoid that.
Yeah. So what do you have in store for us today for case wise?
Well, I always try to have the good ones here, and there's a lot of losses in April, but like there's some really good ones too, starting with Nkenglefac v. Garland, which when it this is an attorney's fees case. So like how can I not talk about that? Like a nonprofit in Nkenglefac v. Garland, and the nonprofit is Immigration Services and Legal Advocacy, gets $55,000 for representing Mr. Nkenglefac, an asylum seeker, before the Fifth Circuit of all circuits. I mean, just very rare that this is going to happen. And when this case came back, because I did this published decision many months ago in the case in chief, I could not believe that I had to say Mr. Nkenglefac's name again, because if you read it, it is a very hard name. An underappreciated thing of doing my podcast, I think, is the difficulty of saying some of these names. More often than people might realize, I literally look up the oral argument to see how the attorney is saying the name, because like some of these names, nothing wrong with the names, but they're from cultures that I'm not always familiar. And so when Mr. Nkenglefac came back, I couldn't believe it. Like, it was hard enough to say it the first time. But this case is interesting because what happened below is his attorneys, they got the Fifth Circuit to overturn an adverse credibility finding, which is hard enough to do. And the reason was apparently that the immigration judge relied upon a credible fear interview, which is not a transcript anyway, but relied upon a credible fear interview transcript that totally happened, but no one ever put it into the record. It wasn't in the record, and the immigration judge was relying on it, and it is just black letter law that you have to rely on evidence that's in the record. So even if, to be honest, if I'm giving the benefit of the doubt to the immigration judge, like this transcript existed, but the IJ relied on it, and it wasn't in the record at all. And to the Fifth Circuit, that's black letter law, need to overturn, cannot rely on something not in the record to make an adverse credibility finding. And it is so wrong that oil wasn't substantially justified in defending it, and the DOJ has got to spend $55,000. I mean, not to be glib, but like the IJ was so wrong that the IJ cost DOJ 55 grand. It's kind of amusing. I mean, and it's also oil for deciding to defend the decision before the circuit rather than send it back, but like, it's kind of amusing. I mean, that's taxpayer money anyway.
Why would oil
it
even
goes
argue
to.
with that?
I'm sorry, what?
Why did oil even? I mean, usually because when I deal with oil, or at least my clients do, it's like for these mandamus cases. And from what I usually hire out the lawyer to file a lawsuit, they say a lot of oil officers, I guess, the lawyers are pretty reasonable. You talk with them, they want to help you and stuff like that. So when I hear something like that, it's like, why would they? Wiser thoughts wouldn't prevail to not pursue that kind of claim.
Yeah, who knows? I mean, in some cases, I'd say that it wasn't even that obvious to oil during the briefing because maybe petitioner's counsel wasn't so good, but that's definitely not the case here because this is a very well-respected attorney and nonprofit. So that wasn't the issue. I don't know, there's all the oil has 300 attorneys or
Yeah,
something, and I believe that they're all very smart um and good professionals. I interned there for 6 months during law school, but like also their discretion is different based on administrations. And at the end of the
yeah,
day, they are supposed to defend the agency decision. So like the BIA said it was okay. Their job is to
that's
defend the
true.
BIA.
Yeah,
So I don't know how it happened. I think all this got litigated during the Trump administration. Who knows
yeah,
if it happens today? But look, this is good. Like, and who knows what the briefing was like? Maybe there was more, and the Fifth Circuit decided to just focus on one thing. You never know. But to have a decision like this, it then gives oil pause
yeah.
and grounds next time something like this comes around to be like, look, guys, we can't defend this. Here's the decision, do it again. So if nothing else, I think it actually helps oil. So it gives them, I don't think people appreciate the goodwill and political liability, political in the bureaucratic sense, that goes into oil dealing with ICE and the BIA that they refer to as their clients. They can't just, it can't, there are stakeholders at every step of the way. Oil has to have some meat to go back to the BIA and say, guys, we don't want to defend this.
One thing is they hate having to give legal fees like this. It's like the bane of DOJ's existence, even when they'll negotiate with people to settle and say don't go after fees and stuff like that. But it seems like they have unlimited supply of money. I'm always surprised when they don't want to pay out or they're fighting it or something like that. It looks like Congress just like constantly like, oh, $1 billion for here, $1 billion there. I'm like, don't they have unlimited money? Or I guess that particular agency doesn't get that money.
That is a question that I am simply not qualified to
Yeah.
answer.
Sounds good. What else do you have in store for us?
So again, well, congrats again to Immigration Services and Legal
Yeah.
Advocacy. They got $200 an hour, by the way, is what the reasonable fee. But there's something I'll get to. I did hear your question. I'll get to the next one in a bit. But I find it amusing. They could have gotten an even larger increase in fees based on a finding that that immigration is a special factor, a special skill that warrants a higher fee. But the Fifth Circuit does not believe immigration is a special skill. So I find that offensive. But still,
Yeah.
they got their 55 grand. The next is
But $200 for
Aladil.
the lawyer is still like it's not enough. It should have been like at least 350, 400 or something like that. But
The next is Aladilli v. Garland out of the Sixth Circuit. It's a crimmigration case, which I'm always partial to. I'm not going to get into all of it, but it regards, there's the immigration ag fell at 101A43 MI, the fraud or deceit crime involving a loss to the victim of over 10 grand. And the fraud or deceit requires the categorical approach. It's got to be a fraud crime. But the 10,000 can be based on the circumstance specific approach, just like essentially looking at a lot of the facts. And in this case, you just gotta love it. Mr. Aladilli in Michigan doesn't return his rental car to Thrifty for 172 days.
yeah,
172 days, the guy doesn't return his rental car. And so and so he has some conviction, which I don't quite understand how it actually involves fraud, but they said it did. But it was about whether or not you meet the 10,000 amount. And essentially what happened is, it seems, is that Thrifty went into court and got him to pay restitution in the amount of just a bit over 10 grand by like throwing the book at him and like airport fees and a like $170 a day insurance type fee. Okay. And so it's
yeah,
like, $170 or whatever it was a day times 170 days, and it came out to over 10,000, right? That's how they got their
yeah.
restitution. The judge says, fine, this guy was like ridiculously late with his car. All right. But in this case, the Sixth Circuit is like going line by line of a rental car agreement, which nobody ever does, and is determining that, like, wait a minute, like, because he was late in returning it, if he had injured the car, then Thrifty would not have given him any insurance. He would have been completely liable. He violated that insurance provision by being so late. So you can't charge him $170 a day for the insurance agreement or whatever it is for something you would have never paid out anyway. This is a contract dispute. This is just you trying to punish him. This is not a loss that Thrifty bore.
Yeah.
This is just punishment of Mr. Aladilli. But the Ag Fel provision requires a loss. What did Thrifty lose? Unclear, but they didn't lose 10,000. So Mr. Aladilli lost, and it's just a very amusing case. And I'm sorry, it's $17 a day times 170 days, but that still got you almost to the 10,000. But either way, because they wouldn't have had to pay out, it can't be a loss.
Yeah.
It's just Thrifty and the judge punishing Mr. Aladilli, which is completely fine to do, but it doesn't equate to victim loss. So if you ever need to attack a restitution order in your aggravated felony argument, this is the case to do it. Really getting into the nitty-gritty of a rental car agreement, to boot. Pretty amusing.
Good arguments by a lawyer to get into that. That's pretty good.
Frank G. Becker, who I do not know, but he was the lawyer, and great arguments. And also, it seems like he was the lawyer from the beginning. So he's been pounding, it seems, this argument since the IJ and then the BIA and two different IJs. He's just been pounding it on this rental car agreement for like a decade. And finally, the Sixth Circuit says, "You're right, sir. You are right." So you love to see it.
Yeah.
And the final decision I have is from the Second Circuit in Malets v. Garland. It's an adverse credibility decision. I also don't like to get into the specifics of those, at least on your show, because it's just too much. But it's very good for omissions and inconsistencies. Omissions are less probative of credibility than our actual inconsistencies. It involves a fraudulent passport. A non-citizen came on a visa waiver passport from Ukraine, and Ukraine's not a visa waiver country. So that's fraud from the beginning. But favorably, and immigration judges want to sometimes say, like, look, you've committed fraud from the beginning. Why should I even believe what you're saying? But there's also case law out there. This case isn't directly on point for it, but there's also case law out there that says we're going to excuse immigration fraud when it's somebody fleeing for their life, And of course, immigration fraud isn't a bar to asylum. It's also an interesting decision because it involves Ukraine, although everything predates the Russia invasion. But most importantly to me is that actually this is the BIA's 2019 precedential decision, matter of YIM. So this decision vacates a precedential BIA decision. And so what does that mean? I've been saying it on my podcast for a while, and I can't figure out the legal reason. But if a circuit vacates a precedential BIA decision on direct review, it would seem to me that that decision doesn't exist anymore because it's been vacated, and no other circuit can rely on it, and no other judge anywhere can rely on it. Now, it's black letter law that, for example, if the Ninth Circuit didn't agree with the decision issued by the BIA, that all that happens is that decision is not applied in the Ninth Circuit and it's applied everywhere else. I get that. But when the precedential decision is itself what's on review, and the circuit with jurisdiction over that decision vacates it, seems to me the decision doesn't exist anymore, and no one can rely on it. Scholars in one article we could find called it a zombie precedent issue, and I've been calling it zombie precedent. It's still alive, but it's really dead. And we're trying to figure out if there's, how to maybe explain this even more. Maybe working on some sort of article or something, but. Matter of YIM is immigration review zombie precedent. And like looking at the difference between the BIA's matter of YIM decision and the Second Circuit's Malets v. Garland decision, which again is the exact same case, it's just remarkable how different judges can look at facts differently and write a completely different decision.
I almost had a comment on something I said in a video on YouTube about like, well, it depends. I need to know more. And it's like these lawyers just want to take your money. Law is, if he knows the law, he'd tell you what it is and just say. And I'm like, it was just said right now. We have two judges, decorated, seasoned experts in the
Yeah,
law. We have completely different results based on the same facts. Yeah,
completely. No, this is the case to show that 100%. Same with the other one, Aladilli. All the facts were always there, exact same facts. Completely different decision between the BIA, two immigration judges, and then the Sixth Circuit on the exact same facts.
crazy. That's law for you. So if the AI takes over, I mean. I don't
Well,
think they'll take over this stuff because it's just I don't know. AI probably won't go this far.
well, maybe you get AI issues when the AI becomes the judges. Then the law is perfect, and then you've got like a what's the Tom Cruise movie with the
Pre Minority Report.
Minority Report
Yeah,
type issue with judging. Like, yes, you're always right, but is it ethical? And then, of course, in Minority Report, they have a way to,
yeah.
manipulate the precogs. But taking that out, there's
I'm not
issues
sure.
even if they're always right.
Yeah, I think Canada is doing a system where they'll do the initial review through AI. So like they'll look at the criteria, then hand it over to an officer. But officers inevitably just going to defer to them. Like, okay, I said this, and people get lazy about this. So inevitably, I was going to get caught up in adjudication, especially with USI stuff, to go over the basics.
That's scary to me because I don't, law is law, fair enough. And we always say you got to follow the law, but like, you also got to add a human component in it. It
Yeah,
might be the case. I mean, first of all, so much of it is right on the line. So how do you make that determination? But even
yeah,
if not, like, sometimes as a human, there's ways to view facts,
yeah.
giving benefits of the doubt based on a holistic view of the facts and the law. And sometimes being black letter isn't always just. And I don't know if AI can ever get to the point where it can further justice rather than simply the black letter law.
Yeah. Yeah, exactly. We shall
Um,
see. Yeah.
Another interesting thing that happened this week, and nothing has happened yet, but I don't know if you saw it on Law 360, the Supreme Court's going to take up Chevron, a direct
Yeah, that was
challenge to the
exciting.
Chevron decision. And this is a bit absurd to me. They're doing it in a case. Chevron's been around since 84, right? Like they've got all the opportunities. This is Justice Gorsuch's desire. He's not going anywhere. And of course, it's going to originate in the DC circuit. I get that. This case does, but like because of when they took it, Justice Ketanji Brown Jackson has to recuse herself because she was on the lower panel. Like you can't find any other administrative law decision except one that Judge Ketanji Brown Jackson was on when she was a judge, and so now she's a justice and has to recuse. So it's going to be an 8 justice Supreme Court deciding the most consequential agency decision ever. And honestly, as an immigration practitioner, I'm kind of cheering on the death of Chevron because it usually doesn't help non-citizens.
Yeah.
But as a human, as an American focused on the EPA, and God help us if judges are just enjoining the EPA as the globe overheats and dies.
I guess with the Chevron decision, it's like immigration was like this secondary, second order problem that emerged for us, was the biggest headache. But it's like it's not the intention. It's EPA kind of thing, isn't it? It's like whether EPA gets shut
Yeah,
down.
yeah. No, in 84 immigration practice and Chevron, like there's barely any circuit decisions anyway from the 70s and the 80s. And Ira is maybe a bit cynical, but of course he's been doing this longer than almost anyone. He's like, yeah, okay, yes, Gorsuch, Alito, Thomas, Kavanaugh want to kill Chevron. They'll probably kill Chevron, but they're gonna make an exception for immigration. Like
Exactly.
that's like I don't know. I
They'll
don't know,
twist it in a
right?
way that still hit the slices us. Yeah.
And if that happens, I mean, then all of the but like they already did it 2 terms ago or last term with West Virginia versus EPA, where Justice Roberts just created the big questions doctrine, which essentially says if it's a big question, then then we don't owe deference to the agency, and Congress the major questions doctrine, Congress has to say so. And if not, we can't, the agency's not allowed to do it. Like, literally made up the major questions doctrine last year. It's what they're going to kill the student loan executive order on this term as well. So you'll have 2 major question doctrine decisions in 2 years, and then they're going to go to Chevron next year. I mean, targeting the administrative state. And to me, say what you want about agencies going too far in the Constitution. I personally believe that in a modern world that's not 1776, you need administrative agencies. But with the world on fire, anything to me that takes away authority from the EPA and the other agencies trying to address this issue is terrifying. Putting immigration aside on your immigration podcast, Mr. Khosravi.
I hear you. Well, thanks again for coming on the show. It's always a good time talking. We had some good laughs on this one. If you want to learn more, really get in hardcore into it, check out the Immigration Review podcast and check out the FBA Conference. Definitely something to go to if you're doing anything in that area. That's the place to be. It's the red hot ticket for immigration practice and hearings and stuff like that. So thanks again, Kevin. I appreciate it.
Thank you, John. See you next month.
For sure. Bye-bye. Have you ever felt that the road to establishing a successful immigration law firm is riddled with unexpected obstacles and setbacks? I've been there, and I'm here to tell you, you are not alone. Picture this. My wife, then girlfriend, and I had just landed for a vacation, only to be greeted by a voicemail that changed everything. In an instant, once the plane landed, she lost her job. The very one job that was supposed to support us while I launched my own solo immigration law firm. Suddenly, our financial cushion vanished, and I was thrust into the high-stakes world of entrepreneurship with no safety net. Despite a slow start and a discouraging lack of leads and referrals, I remained determined to build a law firm that provided a 5-star client experience. After countless hours spent researching, watching, and implementing marketing strategies with mixed results, I eventually began to see my firm's revenues not only surpass my previous revenue and salary as an associate, but double it. Today, I run a successful law firm with a team of associates and support staff, and I'm the proud founder of the Immigration Lawyers Toolbox magazine, podcasts, courses, workshops, and more. But my journey wasn't easy. I made many mistakes, wasted time and money, and wished I had a mentor to guide me through the challenges. Although I was fortunate enough to find a few peers who offered support, I couldn't shake the feeling that there had to be a better way. That's why I decided to be the change I'd wish I'd seen. This month, I'm thrilled to announce the launch of the Immigration Lawyers Toolbox private mentorship and peer group. This exclusive group is designed to bring solo and small firm practitioners in a monthly, private, and intimate setting to openly discuss business strategies, share successes, even exchange invaluable tactics that they wouldn't share anywhere else. By joining this premium group, you'll not only benefit from my hard-earned expertise, but also forging long-lasting relationships with like-minded professionals who are committed to elevating their practices. Space is limited for this game-changing opportunity. If you're ready to make a real, lasting impact on your business, simply email me at info@immigrationlawyerstoolbox.com. Again, that's info@immigrationlawyerstoolbox.com. And I'll send you all the information you need to get started. Don't miss this chance to transform your immigration law firm and reach new heights of success.